He is a reviewer for the Business Valuation Review. He has presented as a guest lecturer on valuation before universities, CPA associations, and bar associations, and his courses on valuation have been sold by data providers including Business Valuation Resources, Udemy, and Forbes. Mr. Sundheim has received security clearances from the International Revenue Service and Canada Revenue Agency and formerly served on the ASA NorCal Board of Directors. And Eric today is going to talk to us all about valuations and business valuations and how that may impact, help, assist, or what have you, our respective practices. Thank you again, Eric, for joining us today. And from here, we'll let you take it away.
Absolutely. Thank you, Alex, Linda, and thanks everyone for joining. I appreciate you taking an hour out of your day to learn about valuation. If I go to cocktail parties and tell people I work in valuation, that's about when the eyes start darting around the room to see if there's someone else they can talk to. So I'm glad to have people interested in what I do. I think it's pretty interesting. And it's something that as attorneys you need to know about. Valuation is an integral part of many aspects of both business and personal finances. It comes up in tax contexts, accounting, litigation, and a lot of the time, the people who need the valuation don't know it. So they're relying on legal counsel to tell them, okay, well, you can set up a stock option plan. If you do that, you'll need a valuation. Or, family law attorney might consult them on getting a valuation in a divorce. So it's helpful to know all the different types of contexts that valuation come up with. I've been doing this almost 20 years and I'm still learning about new ones. So it comes up a lot in a lot of different ways. So to start off with, I'll just give you some background on who I am and why I know about valuation. I think when people know they need a valuation, the first person they go to is their CPA. So there are some CPAs who are credentialed in business valuation. They have a ABV credential. So sometimes you'll see people's signatures say CPA-ABV. AICPA has now made that credential possible to achieve by non-CPAs as well. But in general, somebody who prepares tax returns or does audits is not qualified to do valuation. It's a completely different discipline. I don't do taxes. I don't do audits. So you want to get somebody who is credentialed specifically in business valuation. We're not a licensed profession like you guys, so you can't disbar anybody, although there's certainly a couple people I would like to disbar after reading their reports. But it's not like being a doctor. Anybody can claim to be an appraiser, but there are a few different credentialing organizations. So that is the AICPA, the American Society of Appraisers, and NACFA. So my credentials with the American Society of Appraisers. I won't go through my whole resume here, but you can see that business valuation is all that I do. And I value intangible assets specifically. So there are people who, if you get a mortgage, you probably got a residential real estate appraiser. There's people who appraise gems and jewelry. We appraise businesses and intangibles. So that's stock, IP, cryptocurrency. If you can't put a finger on it, I'll put a value on it. And I do that for private taxpayers, the IRS, been appointed as an expert by judges in California for certain matters. So it comes up in a lot of different contexts, and I'll start going through those now. So here's the 11 different topics I've got planned. We'll see how much we're able to get through. Do feel free to drop in those questions and happy to take those on. I think the first thing that's most important to know before we get into all the different ways this comes up is that evaluation is not a valuation. It's like saying you have a valuation is like saying you have paint. It's like, all right, well, is it the right color? Is it the right gloss? Is it indoor, outdoor? Valuations can be for a company's stock, can be for the enterprise value. They're done as of a certain point of time. So just like you'll see Amazon stock price moving up and down depending on the day, a private company's value will change day to day. So when you have an appraisal, you want to make sure that appraisal is applicable to the assignment that you're getting the value for. So if you're doing something for tax purposes, you want to make sure it's fair market value for IRS. If it's US tax, accounting rules are different. They have something called fair value for financial reporting. There's fair value for minority shareholder dissolution. fair value in divorce. There's investment value, what something might be worth to a particular company. So there's all different standards of value. And when somebody says, I have a valuation, that's usually a starting point for a conversation, not an ending point. Because that valuation you have probably isn't, if it wasn't prepared specifically for this purpose, probably not applicable to the purpose you're envisioning it for. So yeah, this is, I don't know if we can do Q&A. If anyone wants to name this character from the Matrix. Just found out on IMDb, 16th highest rated movie of all time, the first Matrix. Anybody? Agent Smith. All right. So the other way that we can see valuations is in the context of fairness opinions. This became very important after this court case, Smith versus Van Gorkum, in which the judge found that the members of the board were liable, and if they had obtained a third-party fairness opinion, they might not have been liable. So when you have a board of directors, a lot of these, we worked with venture-backed companies, CrowdStrike, Databricks, and these companies have, usually a Series A director, a Series B director, they call them, but these individuals have a fiduciary duty not only to themselves and to the other members of Series B, but to all stockholders. So when they're evaluating a transaction, they need to make sure that it's not just a good deal for them, but it's good for the common stock shareholders. And if it's not, they might get sued. So a fairness opinion is almost like insurance for them, and that it shifts some of that liability from the directors to us when we author that fairness opinion. So if somebody's received a term sheet for an investment, that's when they start to look for a third-party provider for a fairness opinion that's independent. And if you have the bank doing the transaction, if they're issuing the fairness opinion, there's a little bit of a conflict of interest because obviously they get paid if the transaction goes through. So that's why we get sought out, especially for some unique deals. Like we had one deal where both companies had the same CEO. They had a lot of the same investors, but not exactly the same cap table. So there was definitely some conflicts of interest. And so they wanted to get a third-party opinion of, is this transaction fair from a financial point of view? There's fair process and fair value. So we will evaluate the value portion of that element and hopefully provide some level of protection to the company's board of directors. All right, so I'm in Silicon Valley up here. Equity is like sand in the desert and cash is like water in the desert. So we see a lot of equity given out to employees in the form of RSUs, options, profits, interests, and that's all taxable. So just because you're giving some employee or contractor something that's not cash doesn't mean it's not taxable. So there's a lot of tax reporting, withholding. You got to AMT reporting sometimes on Form 3921 to the IRS on what the company's stock is worth. And if it's a privately held company, there's no publicly traded price that's informing you what the value of that stock is. So they obtain third-party opinions of value for that purpose. So this is also important not just for tax, but also for audit. A lot of these venture-backed companies have stock-based compensation listed on the P&L. And the auditor is not allowed to opine on what the value of the company is. They're conflicted from auditing their own work. So they need a third party to say what the value is, but they're also required to test that value. So they're not allowed to just take it and say, oh, well, Eric said that's what the value is. Good enough for us. They have to look into the assumptions we made. So we'll get audit questions, talk through that with them. And it's an important part of the audit process, getting those third-party opinions of value for compensation. So if you're working with a client and they say, we're planning to grant some equity, you need to let them know about getting a valuation. All right, Section 2000. I don't typically do divorce valuations. There's a lot of divorce involving lawyers, dentists, individuals that are maybe sole proprietors or they have a two-person law firm. two partners at least. And when there's a divorce, there's a lot of questions around personal goodwill and corporate goodwill. So a lot of appraisers do just divorce, and the laws vary from state to state. So the person I refer a lot of those projects to, he only does California. I tried to give him a valuation for a Florida divorce. He said, I don't know Florida case law. I don't know how they treat stuff. So they need a different appraiser than me for that. Here, what I'm talking about is more business divorce. So a common scenario we would see is there's a wealthy individual. He's built a real estate empire in California. And then when he dies, he divvies that up among his sons and daughters. And within a few years, some of the siblings don't like how the other siblings are running the business. And they say, look, we want out. Just give us our money. We don't want to be part of this company anymore. So they can force a dissolution under California Corporations Code, Section 1800. They can say, look, we have more than 1/3 of the power in this company. So just liquidate the company and we'll take our proceeds. If they initiate that action, the majority shareholders as an alternative, and they can say, well, wait a second, this thing's worth more alive than dead. If we liquidate the company, we're going to destroy a lot of the value. So let's keep this thing going. We'll just buy you out and pay you what you would have received if we did liquidate the company. Well, then the question is, of course, right, well, what is that value? So that often results in a tribunal of 3 appraisers coming up with a value. So if you're dealing with a client who's not happy about how the business is being run, maybe someone's forced 1800 action on them, know that Section 2000 is an option for them, and they can buy out those unhappy shareholders. All right, there's lots of other litigation where valuation is at issue. I've been involved in some pretty salacious cases. One involved a guy traveling down to Santa Cruz to see his mistress. While he's driving down there, he gets rear-ended, suffers a big injury. He's CEO of a company in the Bay Area that's trying to get sold. Now he's lying up in bed, can't pursue his business activities like he used to before the accident. So he's going after Geico for damages. And one of the measures of damages is the lost value to his business of this car accident. We also see a lot of lawsuits. One time we had a woman who hired her lover as CFO. They went on quote unquote business trips internationally, squandered a lot of money, got no new business development like the purported purpose of these trips. So they got sued. And again, the measure of economic damages was the loss in business value. So experts like me get brought in to say, all right, well, here's the value before they came on, after they came on, and the differential of that is one measure of damages. So if there's litigation and one of the conflicts or issues in the litigation is destroying the value of a business, you can get a third-party appraisal to assist you in pursuing that or defending against it. So to the layperson, when they hear that I do valuation, if I get any response at all, that's usually, oh, valuation, is that like for M&A or something? Typically, parties to sales have their own teams kind of evaluating what they think they should pay for it. But what's at issue in acquisition is not only the fairness opinion element, but once the acquisition has been closed, is the purchase accounting for that. So historically, intangibles didn't go on the balance sheet unless they were acquired. Now we've started to see a lot of capitalization of R&D expense, but it still doesn't capture everything. But acquired intangibles do go on the balance sheet. So it matters if that value that was acquired in the acquisition, if that's developed technology, customer relationships, or just calling that goodwill. So there's a type of valuation we call a purchase price allocation, where we first figure out what the value was in that transaction. You know, if there's some element of stock, we need to value that. If there's an earnout, We don't just take that at the value of the earnout. We kind of come up with some present value, some risk to that being received. And so then we allocate that purchase consideration among the different assets that have been acquired, both tangible and intangible. So when you have a client that's made a substantial acquisition, bought another company, you know that they need a purchase price allocation for that. Chat GPT image. Pretty cool stuff. Another way we can see valuations become an issue is with small companies. Small companies, probably the most important document for these businesses is the buy-sell. It can be part of the operating agreement. Sometimes it's not always a separate agreement, but the buy-sell terms are extremely important. We work with a lot of clients who they might have gotten a prenup for their marriage, but they think, oh, nothing's ever going to happen between, me and my partner, we get along well. We've known each other for 10 years. We've done business for 10 years. We'll be able to figure out any conflicts, or if issues come up in the future, we'll work it out amicably. And just like in personal relationships, business relationships change. Or even if there's not a falling out, you can have one partner die. And then if the interest passes to their spouse, that's not really ideal. So if there's 3 partners in a law firm, you don't want that equity going to somebody who doesn't know anything about the firm. It's not contributing any value to the firm. But you do want that person to be fairly compensated for their holdings. So that's what a buy-sell agreement can help set up. And the way these are normally structured is it's almost like a full employment provision for the appraisal profession. The standard terminology that I've seen for determining the value in a buy-sell is, all right, well, the purchasing party gets one valuation, the selling party gets another valuation. If they're off by more than 10%, which they almost always are, then we got to get a third valuation. So this is time and money. And just like when you're out to dinner, you get that check after the meal comes, you go, wait a second, that doesn't seem right. It's better to agree on the prices and the process for determining value before that check comes. So while you're all sitting on the same side of the table, let's establish this is how we're going to value the company in case I need to buy out your interest. Now, there's hundreds of ways that you can do that. I mean, people look at multiples. I don't really like that because, one, multiples change over time, as we know. So a multiple that you developed in 2018 is probably not applicable to a market multiple in 2025. And that's also an issue that, maybe if that's just a trailing 12 months multiple, as we all know, I mean, last year's performance may not be indicative of future performance or kind of a long-term earning potential. So values can get gamed by the people in that process. They say, oh, we had a great year. Let me force a buyout. So we know that's the multiple. So usually getting some sort of appraisal that considers the broader factors is good. And maybe you can just agree on who you use for that, or you specify 2 firms. We'll use one of them so you keep the process competitive. But that's what we recommend, and happy to send you that standard language that we give our clients when they are executing buy-sell provisions. So usually this is not something you'll get asked for. It'll be kind of incumbent upon you as the outside general counsel for your smaller client. Okay, like you want to form this company. Do you have a buy-sell? Let's talk about getting you one. And then the other issue is going to be, of course, funding that. So a lot of people don't have $1.5 million lying around. So to get some sort of insurance provision in case somebody does pass away is one of the ways to fund those buy-sell agreement purchases. All right. Another one that we've seen a lot of lately is spinoffs. So a common story you might see is a business that's started off as a service company, and in the process of delivering services, they created some software. And this software is actually pretty powerful, and it has use cases outside the context that they're already using it in. So it's really its own business. So they crack open this egg and there's 2 yolks inside, and we want to treat them like 2 yolks. maybe they have a different set of investors. Maybe some investors really aren't interested in the risks of developing a software company, and some do have that appetite. So now you want to spin off that entity. And as you all are probably aware, there's many different ways you can structure spin-offs, taxable, non-taxable. But however you structure it, the new entity needs a basis. So just like you have a basis in some publicly traded stock that you purchased, you need to know what the basis is in that new stock when you create it. So what's typical for us is to value the company as a whole as it exists, the new code that's created, and then also value its common stock, because upon the creation of that company, there's going to be typically some option issuances. So you can do both valuations at once, but they are different valuations. One's a value of the equity, one's a value of the common stock. They have different discounting involved. But doing them as of the same date with the same fact pattern is a cost-effective option for those companies. So new company, new basis. There might be some immediate tax implications depending on how that's structured. But if a client is spinning off a business, they definitely need a valuation. All right, who knows who this is? Kevin McCarthy. No, he's gone. So Big Beautiful Bill has made QSBS even more important than it already was. Cratch knows it's not what you make, it's what you keep. And QSBS is a great option for investors to keep more of the value increases that they've realized through investing in small businesses. So a small business used to be 50 million in gross assets. Now that's 75. So Big Beautiful Bill really upped the advantages of QSBS. And then there's tax savings. So broadly how this works, the way we see it come up often, this guy Tom Bondi up here in Northern California, he is the QSBS expert. Nobody understands QSBS like he does. So we have another interview specifically on QSBS, if you want to look that up, with Tom. And he advises his companies, say, if you're going to be in this for the long haul, let's initially form you as an LLC. Then we can convert that LLC once there's some value, convert that LLC to a C Corp. And you get to exclude up to 10x of your investment in the C Corp. Well, what you're investing is the value of that LLC. So if you convert 20 million in value, then your potential exclusion is 200 million in gains. So it's a great tax strategy, totally legal, ethical, but you do need to know the value of the LLC and defend that value before the IRS upon conversion. So valuation comes up in a number of ways for QSBS, but one is from this LLC to C Corp conversion. And when you're consulting a new company on what type of legal entities they should choose, where they should incorporate, this is a strategy I highly recommend. Obviously, it depends on the type of company. If they're a venture-backed company, Coastal is not going to want to invest in an LLC right off the bat. So there are some where this just isn't going to be practical, but if it is, it's a great deal for everybody involved. And just know that you'll need a valuation when you convert from an LLC to a C Corp. All right, estate and gift transfers. Gift was a word that threw me off initially when I got into this, because I was always thinking of gifts as like charitable gifts. But in the estate planning context, when we talk about gifts, it's like a gift to potentially a son or daughter or other family member. We also have very favorable estate planning law at this point in terms of exemptions. It used to be that if you're in California, just owning a house could put you pretty close to getting above the exemption amount, but it's now a pretty high amount. But there's still plenty of people here that are going to be above the exemption and going to need to pay tax upon death. Frank Luntz, it's a guy I met in DC, the person who coined the death tax, estate tax, same thing. But you got to pay 40% federal on anything above the exclusion amount. So that's a big deal if you want to leave value to your kids. There's lots of ways to try to avoid that. And one way is through family limited partnerships and gifting interests over time. So if you have $100 million company, that company, by the time you die, might be 200 million in value. So better to gift the interest now when the value is lower. And when you gift a fractional interest in that company, so you gift 10% of your $100 million company, the value of that fractional interest is going to be worth less than 10% of the whole. And that's because we take discounts, lack of control, lack of marketability. The IRS tried for many years to argue, well, that's not fair. You're giving it to your son. It's all in the family, literally. So you're all acting on a coordinated basis, but they have lost that time and time again in court. And the courts have said, no, you need to value a 10% interest using the fair market value standard. And that standard says you're not looking at the actual seller and the actual buyer. You're looking at a hypothetical seller and a hypothetical willing buyer that are unrelated. So who's going to want 10% in this privately held company? They have no control over the finances. They have no control over when the company is going to sell. If the company decides to get a private jet for the CEO to fly around to different business meetings, that's an expense they're not going to be able to block. So there's big downside to having a minority interest in these privately held companies. And we need to take that into account when we value a fractional interest. So usually 10% of the whole is, again, worth less than 10% of the whole when you take those discounts into effect. So valuation is critical when making these gifts. And then we still do have charitable gifts as well. So somebody's taking a charitable deduction for some gift they've made. If you're contributing or claiming more than $5,000 in your deduction, that needs to be substantiated in a valuation report. The appraiser is going to fill out IRS Form 8283 and say, yes, this is the value. Here's what's being transferred and stated in the report. And I'm signing off on that as an appraiser. So whether that gift is what we conventionally think of a gift, or whether that's an estate planning tool, if you hear someone say, our CEO is making a gift, that's incumbent upon you to ask about value and how that's going to be determined. One thing we see a lot of for gift and estate is it's like around Series D. It's when these CEOs, COOs start to get paper rich and they realize, all right, we're going to have a transaction some point soon here. Better to gift now than, if everything goes according to plan, the thing's going to be worth a lot more a couple of years. So we might be doing a valuation for the company at B and C, and then we start to do another valuation for the individual for their tax reporting. All right, personal goodwill. This time it's personal. We talked about personal goodwill and corporate goodwill in the context of a divorce. Well, this is also important in the context of a sale, especially when it is a C Corp structuring the transaction as an asset sale instead of a stock sale. C Corp selling assets typically involves taxation at the corporate level and then at the shareholder level, personal level. But these can be structured such that if the fact pattern aligns, and it's really dependent on the facts, but let's say you've got a law firm or a CPA firm, they're doing maybe a couple million in revenue, and it's 100% owned by this John Smith, and the name of the firm is Smith and Associates. John Smith makes all the sales. He's involved in every project. Then what's really being sold there is a lot of John Smith's goodwill and not so much Smith and Associates goodwill. And so that personal goodwill only gets taxed once, the individual level. So when you sell the company, you would then need to come up with an accounting for, all right, well, we're going to receive $5 million in this deal. How much of that do we allocate to the personal goodwill, and how much do we allocate to the corporate goodwill? And again, it's not something you can always do. And the facts are, you know, very important case to case. Is there an employment agreement already with the company? Was it originally founded as a sole proprietorship and did they already make all the personal goodwill a corporate asset by transferring in the process of becoming a C Corp? These facts all matter and they impact the value. So there's a lot of discretion in all these, and appropriately so. We can't just take a rule of thumb and say, oh, the values, 40% of it's always personal goodwill. A fun part of our job is that every case is different and every value is different as a result. Linda, do we have any questions come in?
So far, nothing in the chat. So feel free to keep going. And anyone with any questions, please put it in the chat box. Or if you don't mind it being recorded, of course, just go ahead and unmute yourself.
Yeah, lawyers don't like to be recorded. My dad was an attorney. He actually was the chair of the Palo Alto Bar Association. And so when I was growing up, he would commonly say, nobody likes attorneys. That's not true. I love attorneys because attorneys are often ones who, again, inform their clients. You need a valuation report. And so we get a lot of referrals from attorneys, CPAs, bankers are a good source.
And I see we have a number of tax attorneys on the Zoom. Perhaps we can call on them just to see how closely do you work with, say, tax attorneys and CPAs?
Yeah, often we get questions that are not strictly valuation questions, but because we do the tax appraisal, we start getting tax questions. So some of them, we do feel comfortable answering, but a lot of times that's a way it flows in the other direction where we say, I think I know the answer, but you're better off talking to a tax attorney on this one. Lots of good strategies that the tax attorneys have. I love that saying. It's from actually a wealth advisor. It's not what you make, it's what you keep. So it's really important to do tax planning at the beginning. A lot of the venture-backed companies that we work with, they think that taxes are going to be a nice problem to have, and we'll jump off that bridge when we get to it. But failing to plan is planning to fail. And, the whole enterprise or endeavor only makes sense if you do have everything targeting that positive outcome, and you want to optimize your taxes and make sure you do all the appropriate valuations along the way, assuming that you are going to have a positive outcome, because if you don't, what's the point?
And can you talk a little bit about when you do come onto a case, what the first steps are, who reaches out initially, and where do you go from there?
Yeah, there's a lot of different ways we get introduced. A lot of times, like when I was doing today, was a second opinion. Like, hey, this is what they're telling us. Can you take a look? Sometimes it depends. We can sometimes do that at no charge. Just to, if it's coming from a friendly source, it's kind of a favor to the attorney. Happy to take a look. Otherwise, it may come from someone we've worked before. In Silicon Valley, it's very incestuous. People jump around from company to company, and we have a lot of fractional type of service providers. So temp CFOs, fractional general counsel, and they're working with 6 different clients. So when they pick up a new one, we pick up a new one because they bring us over there.
And can you also discuss, in terms of business ownership and valuation, how often does the business owner have one number in mind and yours is quite different? And what do you do to get to a compromise?
Yeah, expectations are frequently a problem. That's something you need to talk about going in. in the context of a sale, like, if you're selling a business, a small business, and you want to maximize the value, usually a business broker is your best bet for that. But a lot of the problems that those business brokers have is they have a conflict of interest too. So they'll shop around the business owner to 3 different brokers. One says I can get you 7, one says I can get you 8, one says I can get you 12. It's like, oh, I like 12. I'll go with that guy. So it's important to recognize when there are conflicts of interest like that. A lot of small businesses are not saleable because of that issue of personal goodwill, or maybe they're not of a size that they'd be attractive to a buyer. So, a lot of business owners in that context generally think the value is higher than it should be. If you're doing something for tax purposes, the client will may want the value to be low for some transfer reasons, but they also don't want the value to be wrong or to be questioned by the IRS. So it's helpful to work with somebody who has worked for quote unquote the bad guys, being the IRS, and know if you do this, yeah, it's going to get you a low value, but it's also going to get you audited, and it's not worth it to get so aggressive on the value if it's going to be something that gets you into trouble.
Okay, and I see a question in the chat box. Are you able to appraise artworks, jewelry, other forms of personal property?
I'm not. So I'm a member of the American Society of Appraisers, and we have a number of different disciplines in there. Machinery and technical specialties, MTS. These guys look at like equipment in a factory. Gems and jewelry is one. There's somebody, I think he's the only ASA who is accredited in appraising libraries of recorded music. So I think he did like Michael Jackson's estate. So there's definitely different specialties. If you do need a referral, the American Society of Appraisers has a Find an Appraiser website. So that's a good place to go. You might also reach out to me and say, hey, I know you don't do artwork. Is there somebody you might recommend? And there is an appraiser, a real estate appraiser here. She knows everybody. So if I don't have one, I usually go to her and she's able to get people where they need to be.
Okay.
I'm curious to know the context that that's coming up in, if that's an estate valuation or.
Great. I'm looking at another question. What are the appraiser compensation arrangements and amounts? Flat rate, hourly, percentage? How is that worked out?
It varies. So my first job was working for someone who only did expert work. Everything was billable and was on timesheets all the time. In the financial reporting tax world, clients typically don't like that arrangement. They want a fixed fee. So something like a 409A valuation like we do here for compensation, that's something we typically offer for a fixed fee. I do have a term in there because, as I mentioned, the auditors will want to review the report. And sometimes my kind of cynical view of that is that if they're having a slow month, they're like, oh, great, let's ask a bunch of questions about 409A. We can bill on that. So they're getting paid by the hour. We're not. But I don't think I've actually ever practically had to enforce that additional like hourly on top. So sometimes like in M&A context, we'll do the same thing. We'll do like fixed fee, and then who knows, like if discussions go beyond that, hourly on top of that. But anything in an expert context, that's almost always going to be retainer and hourly work because it's varies, and you may be 25% into the engagement, everybody settles, pencils down. So doing things hourly just makes sense in that context.
And
Eric,
normally, what
I have a
kind of
couple of
time frame?
questions.
Oh, go ahead, Haraj.
The code sections that you had cited on a previous slide, 2000 and 1800, were those the California Corporation Code? Yeah.
You got it.
And then can you go to slide 14? So here, the personal goodwill issue. Could you expand on that and maybe discuss based on your personal experience and how you've been able to segregate the personal goodwill out of the company, and what type of documentation you've seen in that context?
Yeah, so it is, again, it's all fact dependent. And so we need to establish what those facts are when we do the valuation, and figuring out what is the level of personal goodwill, if any, that has not been, it's not a corporate asset. So I've done a couple of these last month, and in both those cases, it's like the whole business is one guy, and if he's not there, the whole thing's going to fall apart. All the relationships are with him, both on the customer side and internally too. If that person was to leave ABC Co. and start 123 Co., all the employees would just go with him. So you want to measure, one way, there's two different methods. One is more qualitative, and I'm not a big fan of it, but it can be good as a kind of corroborative method to determine the relative values. But the method that I'm most partial to in these cases is the with and without method. In that case, you would value the cash flows the business would achieve with this person and the cash flows they would achieve without this person. And the difference between the present value of those two sets of cash flows is the value of the goodwill. On top of that, there's a tax amortization benefit to that acquirer. When they acquire that asset, they can amortize it. So you get to kind of step up in a way the value of those business cash flows based on the amortization factor, which depends on the different assumptions or their discount rate you're using. That can be like another 12% on top of it. But again, okay, well, here's the value or cash flows with and without, just like in any forecast. It's like, well, how'd you come up with that number? So those needs to be substantiated assumptions, but there are established methods for coming up with that. So I mentioned in the acquisition context for the purchase price allocations, that's a common method we use to value customer relationships, a non-compete agreement. So, and it's not like, it's just kind of in a litigation context, you might run across like duty to mitigate. You can mitigate in this case too, right? Well, if the person were to leave, maybe we'd hire another salesperson and we'd have some incremental expense. And also if they were to leave, we wouldn't be selling as much, so our COGS would be lower. So it's not a pure subtraction exercise. There can be some mitigating factors that make that differential a little smaller. It's kind of a long answer. Did I get all your points in there, Harach? Or?
Yeah, and in certain circumstances, businesses can be very profitable where you have the owner has a lot of personal contacts, and that's where all of the goodwill is. The determination has to be made of who owns that goodwill, whether it's the owned by the entity, the corporation, or is it personal to the owner?
Yeah. So is there an employment agreement?
Is there some papering going on to figure that out at that point, or is it? I assume that there's the founders have not thought about that until kind of at the.
That's absolutely true. Yeah. So this is not an issue that they're aware of until the sale comes about. So they go, oh, actually, we did have an employment agreement and we did have a non-compete that we already executed. We weren't thinking about it back then. Or we did transfer all my personal goodwill to corporate when we formed the corporation, transferred it from a sole proprietorship. So it's sometimes, we look at the facts and says, I don't think we can come up with a value, but it seems like your personal goodwill is a corporate asset at this point. So it wouldn't be worth it to come up with a value. And there's a couple of cases on this, both good and bad. The good one is Martin ice cream. So that's when people started to become aware that, oh, wow, this is a valuable strategy, and it made it through. So that was a win for the taxpayer. Then in the other court case, which name escapes me at the moment, but that was a victory for the IRS. And it wasn't an issue there of having different judges or different jurisdictions. It was a different fact pattern. So one case, the fact pattern supported separating out personal goodwill, and the other case it didn't.
Thank you. And can you
Thank
talk
you.
a little bit about the time frame? Like, what's the shortest you've gone in and done this? What's the longest, and how big were the companies?
Yeah, litigation can go on years. Sometimes when I do these litigation assignments, I think, wow, 2014, where was I in 2014? That's even before we get involved. So litigation, very extensive. Sometimes the fairness opinions are going to be the ones where it's fast. Somebody's got a $600 million deal on the table. They don't want this being held up by, Mercovis. Say, well, hold on, we gotta give us another couple of weeks so we can do our calculations here and make sure everything's, um, done correctly. So fairness opinions can happen fast. I almost don't want to say how fast because then clients will start to expect that. But we do budget for that. So we try to, it's tough as a small firm, as I'm sure attorneys know this very well. We try to leave some capacity where we're not already burning the midnight oil. So if something does come in that needs a quick turnaround, we can service that.
And what do you do about when one partner thinks it's worth something and another partner, wildly disagrees? Um, how do you find the middle ground in that? And
Yeah,
what is your job in that?
yeah. Sometimes, we do deal with partner buyouts. I was working with a construction firm, and this was not a case of somebody dying. It was just they wanted out of the business, and people's perception of value is influenced by their personal circumstances. There's a legislator. He says where you stand depends on where you sit. So you definitely see that come into play. I joked that, in these types of transactions, if the buyer thinks the value is too high and the seller thinks the value is too low, I've done my job. So both people are unhappy typically with the right value. But there's other professionals besides us that are involved in the process. So it is the case, we can't take a assignment contingent on coming up with a certain result. We're not going to give somebody a lower value just because that's what they want. We're prohibited from doing that, both ethically and through our professional standards. But we do sometimes have to play the role of counselor and just get people comfortable with what we have come up with. And then there's other professionals that are involved with that too, like a mediator. And a mediator can say, well, this is what Eric's telling you. And in my experience, having gone to court in many of these cases, the position you're taking is not going to be viewed favorably. So you can take things as they are now, or you can spend another $1 million and get the same answer 4 months from now.
And because businesses are so often changing, how many of your cases are still family-owned businesses as opposed to more on the corporate level? And have you seen that change over the years?
FLPs, family limited partnerships, I feel like those are on the rebound. I feel like those went away for a bit and now they're becoming more popular. And we are in Silicon Valley, so most of our clients are venture-backed technology companies. We were doing AI before it was cool, before ChatGPT made, LLMs kind of a household name. So tech companies, software, medical devices, that's been around for a long time. It's going to continue to be around and exist. But you see a lot of these small businesses, and sometimes I think, man, I got into the wrong business. This like a electronics company, they're just make some PCB boards and they're killing it. So more money, more problems. Usually those companies have valuation issues too for estate planning or other tax reasons, and they need a valuation to help them with that.
And because you so often work with Silicon Valley companies, how have you seen AI change the dynamics? Does it particularly help in your field?
Yeah, it's helped us do better work. So we use software. I mean, our subscription fees for software are 5 figures, and it helps us automatically populate with market data. I was talking to another appraiser up here, Max Fonarev, and he was saying when he first started, if he wanted company financials, he would call the company. They would send him some book, and he would look it up on page 37, enter it into the computer. Now you just populate that stuff automatically. You just stick in the ticker symbol, and it'll give you, you tell it, I want it as of this date. Here's the balance sheet. Here's the last 5 years of P&L. So that's the good of software, is it helps us do a better job. The bad is that you have some people saying they can do software evaluations, just like I'm sure you see with LegalZoom, or which has its place in the market. But oh yeah, I can put my numbers in here, bit boop, beep boop. Here's your value for $199. The software will tell you what it's worth, and that's bad because it really ignores the fundamentals of what we do. Is it's applying judgment. So yeah, you can put in to some software program, tell it, oh, I just raised Series B at 250. Tell me what the common's worth. But the software didn't ask you, oh, was that investor strategic or financial? Oh, you also executed an IP licensing agreement with them? Well, maybe they gave you good terms on that and they got bad terms on the pricing, or vice versa. So there's a lot of just simple things that get missed, that maybe the AI will get there someday, but it's certainly not there yet. And I'm sure you've seen it. They have actually talking to a prospect that does like contract review AI. So it's the same thing that the legal industry sees, I'm sure.
Great. And how often do you see, if a company's unhappy with the valuation that's been delivered through no fault of your own, that they go out and do it all over again with another appraiser?
We do
Does that happen?
we do see that sometimes. And actually that same person, Max, was telling me that it's not incumbent upon the company to accept the first answer that they get. So that's something that's within their rights to do. Is they don't like a value, they disagree with the appraiser, go get another one. I'm sure that could come up in discovery, that you did receive a different appraisal. So, but it doesn't mean that they're automatically going to be found at fault for doing anything incorrect. These are great questions, by the way, Linda. Thanks for keeping this going here.
Great. Let's see. If anyone else has anything else, please feel free. We have another few minutes. Anyone, you could unmute yourself or simply put it in the chat box. Okay, I think I have one. I'm not sure we had this one. When there are two conflicting professional appraisers, do you get an expert witness to point out the errors in the other party's appraisal?
Yes. So we do both affirmative opinions of value and then kind of rebuttal reports, where we can look at others and say, here's what they did wrong. If there's also cases like I mentioned in the standard buy-sell terms, where the third appraiser is coming in, he might look at the other first two appraisers, see what they came up with, and critique them. I did have a case recently where there was a buy-sell, that process was outlined, and then that appraiser that came in to do the third valuation, like 2 months after he authored that affirmative valuation, he delivers another report to my client, and they said, oh, and by the way, here's what's wrong with that other report, which was not outlined as part of the buy-sell process. So this was just some creative endeavor by the other side to engage that appraiser. I'm surprised they took him up on that. So we do get called in to critique each other's work, which is part of what makes it fun. When I was in college, if I was lucky, a TA would spend 5 minutes looking at my papers, and I put a lot of thought into it, and I wanted people to think more critically about it. And in this role as an expert, I mean, we are getting comments like, hey, we want the quotation marks. You know, these are curved. We want them straight. So people are really paying attention to what we do, and keeps us on our toes, keeps us sharp.
Right. I do see in the chat box, we do have some more. I think we did talk about the rates already. One wanted to know if you did work for the IRS, and is most of your work related to tax securities or other issues?
Yeah, so I have a security clearance with the Internal Revenue Service. I've done work with them on a number of very large cases. So I've worked for the bad guys and the good guys. Also worked with the Canada Revenue Agency, Australian Taxation Office. That's their version of the IRS. What percentage of our work is taxed? Probably more than 50%.
Interesting. Okay, I think we handled it. I think you handled the rates, right? He asked about the appraiser compensation arrangements and amounts, flat rate, hourly percentage, and is it based on the amount out issue?
Okay, so that's another thing we're not allowed to do, is we're not allowed to base our fee off of the value that we're coming up with. Clear conflict of interest, there is an exception to that. They call it a jurisdictional exception rule. And the only one that I know of is probate. So if you were hired by the probate court does compensate appraisers based on the value. Funny that, huh? A little conflict of interest. I've never taken on those assignments, but that is something that we are prohibited from doing through not only the American Society of Appraisers, but also through the Uniform Standards for Professional Appraisal Practice, USPAP. But USPAP does have this jurisdictional exception rule. They say, well, if it's carved out by the government and that's the law, then okay, go ahead and base your fee based off your value.
Okay, and I'm looking, is this a new one? I don't know if you could say this one. Would like to know the hourly rate, if there is one, if you may provide. I don't
Slip
know.
into my DMs. Happy to discuss.
Right, and I think your contact information is on the handout we sent.
I hope so. Sundheim@mercovis.com. I'll put on the screen here. There's our general email, info@mercovis.com, and telephone number 408-599-1377.
All right, and the last, I believe, sorry, it's hard to read these. Also, what worries you the most when reaching a result? The IRS, the SEC, or someone else?
It depends. And boy, I saw the SEC pop up on one of my cases, and I was very surprised to see that as a private investment fund. But since they raised funds out of state, interstate commerce, and now interstate commerce clause allows SEC to regulate that. So sometimes I am shocked where the appraisal actually becomes an issue. And we've seen CEOs get fired in ways they never thought it would be an issue. So maybe a CEO came on board, he wanted a really low value, so he wouldn't have to pay tax on his equity. We got kicked out as the appraisers because he didn't like our value that was higher. He got a garbage appraisal. The auditors looked at it and said that this is not the value. We can't sign off on this for the audit. Well, now you don't have an audit. Now you're in violation of your bank covenants. And so the CEO got fired. Like, we received emails from a separate counsel and said, do not communicate anymore with this client. Like it's where's the issue going to come up? It's hard to say. Sometimes you know, sometimes you don't. And that's why, do these with the assumption that somebody's going to look at it.
Terrific. I think that does it for us. Thank you so much, Eric, for your expertise. And we so appreciate you presenting for us today. Again, MCLE certificates will go out later this afternoon. Thanks again. Thank you all for joining us. Have a great
Thanks, everyone.
day. Thank you all.